Welcome to another episode of Awaaz in Focus, an initiative of Azad Awaaz. This monthly patrika focuses on marginalized sections of the societies whose voices are often muted in the cacophony of flashy mainstream media discourse. When talking about marginalization, this platform does not aim to only focus and put caste on only caste and race alone, but also aspires to include discussions on class, gender, and identities as well as the environment. This month's Patrika focuses on accessibility of reproductive rights of persons as well as adolescents. This Patrika looks at different facets of reproductive rights, such as the legal framework behind it, how accessible is it for vulnerable communities, and the social and structural issues that comes with it when it comes to accessing these rights. Today we have Professor Avantika Chawla with us today, who will help us understand the Medical Termination of Pregnancy Act as well as the legal framework and developments when it comes to reproductive rights. Let me introduce Professor Avantika Chawla. Professor Avantika is a professor from Jindal Global University and was also a former student of the university. Being one of the brightest students of Jindal, after graduation, she went on to working for a boutique law firm in Bombay. Soon after realizing that the work she was doing wasn't fulfilling, she then went on to work for the Council of Secure Justice, and she represented a lot of children who were victims and uh, most importantly survivors of these sexual assault. Then she went on to pursue her LLM from Leiden University and specialized on international child rights. Then she joined Jindal and is currently teaching the law school and also is heading and is an assistant director for the Child Rights Clinic, which works on policy and also does advocacy work for children's rights. And she also takes an elective on child rights. I am a former student from Professor Avantika's class, and it's such an honor having her today. Thank you so much, Professor, for joining us today.
Thank you so much, Harshita. It's a pleasure being here.
So let's just begin with the discussion, Professor. So my first question to you is, what is the Medical Termination of Pregnancy Act, and what is the law surrounding abortions in India?
Right. So the Medical Termination of Pregnancy Act essentially seeks to regulate abortion services in India or medical termination of pregnancy services in India, and any abortions that are done outside of the ambit of the MTP Act are punishable under the Indian Penal Code. Right. As far as how MTPs work or what is the regulatory framework surrounding that, essentially persons can get abortions up to 24 weeks, right? And beyond 24 weeks, there's a medical board necessity, right? So I'll just quickly break that down before we delve further into our discussion so that we can all just be on the same page, right? So up to 20 weeks, if a person is pregnant, they can get their abortion or they can get their fetus terminated by the reference of one registered medical practitioner, right? And now, then, if the abortion or the fetus is between 20 to 24 weeks, one needs the approval of two registered medical practitioners, right? However, within this framework of having two registered medical practitioners, one also needs to fall in the categories that are mentioned under the MTP Act, right? So the first category is that if the continuance of the pregnancy would involve a risk to the life of the pregnant woman or grave injury to her physical or mental health. Now, this word grave injury also includes if a person has suffered sexual assault. And it also includes the fact that if a person is a minor. And we can find this under the MTP rules, right? And the second one is that there is a substantial life to the there's substantial risk to the life of the child, and if that child were born, they would suffer from mental or physical abnormalities, right? So in these instances, abortion between 20 to 24 weeks can be done, but one must fit within the ambit of the instances that I have mentioned, and then you need the approval of at least two registered medical practitioners, right? Now, beyond 24 weeks as well, medical termination of pregnancy may be done. However, for such medical termination of pregnancy, you need to approach the medical board. and it can only be done if there's a diagnosis of substantial fetal abnormalities, right? So essentially I would say that it is up to 20 weeks wherein persons really have the freedom to get abortion done, and beyond that 20-week period it is regulated. So right, so for 20 to 24 to registered medical practitioners, only if you meet the conditions that are mentioned in the act therein, and beyond 24 weeks one needs to approach a medical board, right? But I also want to give a slight disclaimer here, right? Especially because I know we'll be delving into talking about reproductive rights of adolescents and of young persons. It is really quite different when it comes to adolescents and young persons, which I know we'll delve into later, wherein even when the fetus is under the 20-week period, it's 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 very difficult for adolescents and young persons to really access abortion. Yeah.
Thank you, Professor. After hearing your brief explanation of how MTP is laid out and the timelines of obtaining abortions for persons, my second question is actually bringing on a little more focus towards that. So, under the MTP Act, that it does not give the whole right to abort for a pregnant person. Like, a pregnant person does not have that whole right. This is a need to have the termination authorized by at least one medical practitioner. Many countries don't even require this authorization of medical practitioner it till 12 weeks mark. Since the advice of a medical practitioner is needed in India, is the autonomy of an individual lesser, or is the due authorization actually required? What are your takes on that?
Right. Honestly, I think it has a lot to do with the intersectionality aspect that you really spoke about at the beginning. It really has a lot to do with that. Because I feel like, as me being a person of a certain class and a certain caste, if I were to go to a registered medical practitioner, it may not be as difficult as for me to get an abortion done, right? However, once we situate this and we bring in intersectionality, it really is hard, and especially in the context of young persons and adolescents, because in their case mandatory reporting kicks in, which we will delve into in detail. But in their case mandatory reporting kicks in, and we have cases wherein the fetus has been way under the 20-week limit, even at 8 or 9 weeks one has really not been able to access abortion services, right? So I do feel that rather than it being an approval or sort of like an getting approval, rather it should be that it should be done on the guidance of a registered medical practitioner. Because at the end of the day, an abortion is a medical procedure, although of course in many instances it may be non-invasive, it is if it is done by the way of pills, etc. But there is a possibility of complications developing, so definitely needs to be done under the supervision of a registered medical practitioner, right? So it shouldn't much be an approval that is required. It should be more of a supervision that is really needed, right? Because at the end of the day, even in order to actually undergo a MTP, it's not that I can go to the hospital and say, hello, hi, I want a MTP, right? That is not the way that it would work. There are a series of tests that will be run, and only on the basis of those tests the doctor can advise you as to what the correct route may be, right? For example, in fetuses that are much younger, right? So perhaps if the fetus is only at 4 or 5 weeks, or sometimes even up to 7 weeks, they conduct abortion by way of pills, which is a non-invasive procedure. But then again, if you are beyond that period, then they may have to do a DNC or use any other method. So for that, we definitely do need a medical practitioner being involved. But I think it shouldn't as much be an approval of a medical practitioner as much as supervision of one. Because at the end of the day, it is the person's autonomy. And I think that has been very rightly pointed out also recently, last year in X versus Principal Secretary of Health, where the Supreme Court has very clearly stated that the rationale behind the MTP Act is to ensure that persons have access to safe abortion, right? So if that within itself is not met, then the MTP Act is not going to be very useful at all. So I do feel that safety aspect of it has to be kept in mind, and it has to be more that one should consult with the RMP and not really as much require the approval of an RMP.
Professor, why do you think that there is this authorization tone in the legislation, though?
Right. I think that the answer to that is one that most of us probably already know, right? At the end of the day, it does have something to do with autonomy of a woman. And I feel like that can never really be free from the system and from the socialization that we all have in terms of the state's constant need to try and control a woman's body and a woman's autonomy. I think it really does go to that, right? And I think it has been done in the garb of, oh, we're trying to prevent female infanticide and things like that, right? So not to say that that problem does not exist. I think even today in the 21st century that problem is very real, which is why I do understand as to why you may still want to ensure that there is consultation with the RMP and you don't want to make it completely free, right? But I do feel like that is what it's really rooted in. It is rooted in the state's need to control a woman's bodily autonomy.
I also think that, and I think, adding on to your point, Professor, I think it's also an issue that our judiciary always makes it out to be that abortion is a very much a woman's right in India. It'll never be taken away. But then, we seem as a pro-right country, but it has, back ends of it as well. Yeah, so I think that was a wonderful discussion. So moving forward, to understanding further, the understanding of ambit of who MTP applies to. So my third question to you is, the MTP Act uses gendered language such as stating pregnant women or women. Therefore, it makes the applicability of the act just for a biological or said woman. How do individuals who conform to different spectrums of gender, such as one of the biggest one we have seen is trans male, and even further, like even let's say intersexes and as well as non-binary individuals, how do they all access abortion? And has there been any case where queer individuals have been permitted to abort?
The law equally applies to everyone, right? There is definitely the language that has been used in the. Actually, you know what? I would like to change that statement because the law in theory equally applies to everyone. Because when it comes to these more intersectional issues, we do know that they are fraught with many more hindrances than a cis individual would, right? So, and this was actually, again, I keep going back to X versus Principal Secretary, but I think it's one of the most well thought or it was a well thought out judgment. It does, of course, have its drawbacks, which we will also be discussing in a minute. But I do feel like X versus Principal Secretary also pointed that out, wherein they said that the language that has been used is very gendered. Right, and there is a need to strive to use more gender neutral language in our legislations, especially because as society has progressed now, especially over the last few years, there has been a much more pronounced recognition of persons belong to all genders, all the way from the Nalsa judgment up until today. I feel like every day, at least the judiciary is taking a step in the right direction. Not to say that sometimes things don't go wrong, but I would say that definitely, especially in the last few years, and especially since Nalsa, I think there has been that recognition, and that needs to really percolate into the act itself. Because of course, if there was a trans man who were to approach a practitioner for an MTP Act, I am 100% sure it would not go very well. Because even the whole issue with X versus Principal Secretary, it was just about an unmarried woman wanting to seek an abortion, right? So even then, there are so many questions that are raised. So even though legally that person would not really have an issue, because they are very well covered under the ambit of the act. However, what about the issues that they will actually face when they go to seek an abortion? Right? And especially so because they are a trans man at the end of the day. And when they do go to seek that abortion service, they may very well be told that you're not a woman and hence you cannot, hence, you cannot get an abortion. So I mean, I think that there needs to be a lot more I think even with medical practitioners, especially, we really do need to have more training and more awareness on how to also deal with persons who don't necessarily conform to being a cis person or being a cis woman when it comes to the MTP Act, right? So I feel like definitely we do need an amendment in the Act wherein it is made more neutral to also ensure that individuals who don't conform as cis women are also covered under the ambit of the Act, wherein they also feel more seen under the ambit of the Act, because I think that also goes to a lot, right? It's also about being recognized and about being seen. So I feel that being done is definitely a good step, right? And I think that's definitely something that should have been done yesterday, but I think it's time to do it now. And along with this, I think also including these nuances and trainings for doctors is extremely essential.
I think you have pointed it out rightly, Professor, and I think it really puts perspective for us as viewers of this episode that it is important to understand not just, let's say even though MTP Act went through an amendment, if it goes through another amendment of maybe making the words more like maybe individuals with uteruses are able to reproduce, even if those changes are done practically a legislation being implemented is more about actually the people who are supposed to implement it and get it in practice, who at the end of the day are medical practitioners. So I think without that gap even being filled, I think there is like it would not really bring justice even if, let's say, we amend the wordings of the act, if, let's say, that sort of sensitization is not given by medical practitioners. But yeah, thank you, Professor, for answering that question. So moving on to something that I feel like I've heard you talk about previously also in class, which is understanding the discrepancies of the POXO as well as the MTP. So currently under the POXO section 19, which is the section that states that there must be mandatory reporting if there is an apprehension or knowledge of a child being sexually assaulted. How does this section impact section 5A of the MTPA, which is a section that talks about confidentiality and ensuring that the details or particulars of the case that a person goes through abortion should not be put out publicly. How does this contradiction in law coexist, and has there been any middle ground that courts or other authorities have been able to establish?
Right, absolutely. I think this is a very pertinent question. I think, especially when you are speaking to someone who works in the realm of child rights. And, this is really what I wanted to touch on also at the beginning of our conversation. I think, firstly, I just want to lay down the law a little bit, which I know you've very aptly done, but also to speak about the language that is used in Section 19.1, right? So, Section 19.1 essentially mandates the reporting of the knowledge or the apprehension of any offense under the act having been undertaken, right? Because they don't use the word sexual assault because, as you remember, Harshita, sexual assault is a particular offense under the POCSO, right? And then we have section 21 that actually makes it a punishable offense. So if one fails to report, then there is up to 6 months of imprisonment. And if you're the head of an institution, up to 1 year of imprisonment, right? So that is really where the criminality of it also comes in, which is why it is something that ends up hindering a person's rights, which we will just get to in a minute. So essentially, why is this an issue, or how does this create an issue? Because under the POCSO, as we already know, the age of consent is set at 18, or essentially all persons under the age of 18 are covered under the POCSO, right? Meaning that the sexual age of consent in our country is 18. So, what that essentially entails is that if there were two persons who were indulging in consensual sexual activity, and one of the persons get pregnant because of said sexual activity, and they were to go and seek an abortion, the RMP that they do go to would be mandated to report the fact that XYZ person has come to me for an abortion, and they have to report it, right? And then now both the person who is pregnant as well as their partner, both of them get pulled into the legal system. And as we all know, that there is no way that really that ends well, right? Especially with POXO, wherein the punishments are so high, especially if the partner is an adult and cannot be covered under the juvenile justice system, right? And now, given the high punishments under POXO, given the fact that there is a fetus, one has to preserve the fetus, even if the MTP goes through direct DNA match, that's a sure shot conviction, right? So that is one of the issues that stem out of this. So that is one way that the right to access safe abortion services really gets hindered. Now, as you rightly pointed out, the conflict between the POXO and the MTP Act is precisely this. On one hand, the MTP Act provides for confidentiality of the person who is approaching the RMP for a MTP. And on the other hand, we have Section 19(1) of the POXO, which essentially says that mandatory reporting must be undertaken. Now, again, circling back to X versus Principal Secretary, after about 10 years of the POXO being in place, this was an issue that was picked up by the court, right? And the Supreme Court said that we see that there is this contradiction between the POXO and the MTP, and this is leading to the fact that the access to abortion for young persons and for adolescents is getting hindered. So what they said was that if in such an instance, a adolescent, a young person, anyone under the age of 18 approaches a RMP for a MTP, the MTP should be carried out and the information should be given under Section 19, but not mentioning the name of the individual who has come for the abortion. Now, actually, the court gives no guidelines on how it is that this is to be carried out. And that's a mystery, right? And not many states have proactively taken this up and tried to figure out a solution to this. We were, in fact, Harshita, I think you were also part of that discussion wherein we had someone who works in Tamil Nadu who had come in for a lecture, and they told us that in the state of Tamil Nadu, they have come up with a sort of like a referral sheet, or they've sort of come up with the format of how it is that they would do reporting, or how RMPs should do reporting in such instances, right? However, this process neither satisfies the purpose of mandatory reporting, and neither does it satisfy the mandate under the MTP Act. So it's like this middle ground, which I think great job the Supreme Court has given us some headway into that, as to how it is that one should resolve this issue, but how it will actually be done is really a mystery to me. And the thing is that RMPs, because of mandatory reporting, are so scared of doing MTPs. There was a case wherein there was a 9-week fetus. There was no need to approach the court for abortion. But because the RMP was so scared that what will happen to me, they said, sorry, we cannot do the abortion till the time we don't have a court order. And these are cases that are making it to court, right? And even a few weeks back, there was another, I think this was a Kerala High Court judgment, wherein again, there was a 10-week fetus. Why are these people approaching court? Why aren't RMPs giving access to MTPs to these adolescents and to these young persons, right? And each state kind of is fraught with its own issues because people are so scared of this mandatory reporting provision, right? RMPs are so scared of this provision. They don't know how to navigate it. And this kind of goes back to what I was saying earlier, which is the fact that there is a need to train RMPs and to train doctors on how it is that you actually navigate these situations. Make sure that they also understand the law, because in their head, all they know is that, okay, it is a person who's under the age of 18. I have to mandatorily report it. Check, okay, I'm mandatorily reporting it. Okay, I have to preserve the fetus. Right? So if all of these things have to be done, but they don't really know how to navigate it, right? And in fact, recently, on the other hand, on the other end of the spectrum, there was a recent Bombay High Court judgment from just, I think, last month, wherein the High Court actually said that one can subvert mandatory reporting. 17-year-old child was impregnated by their partner, and the High Court said that they could go ahead and give birth without reporting, right? So essentially, they subverted mandatory reporting, and this is how High Courts are taking care of these cases, because there is going to be no change in the law anytime soon, right? We saw that even with the Law Commission report coming in, wherein they came up with this thing that, okay, let's give discretion to judges, but it was so unclear. right? So high courts have also been navigating around this, wherein there are, accepting these compromises, when the underage person and the above age person will get married. That's also not setting very good precedent, but at the end of the day, is justice really being done by sentencing someone to 20 years of prison because they had sex? I don't
Yeah.
think so, right? And just last point before I hand it back over to you, what this also leads to is a lot of back alley abortions then. So these are abortions that are happening in unhygienic, unsupervised environments. And again, it just disrupts the very purpose of the MTP Act, which is to provide safe abortion services, right? And and we have all heard of coat hanger abortions. They happen till date, you know. So the fact that when a child cannot access these abortion services, or a person cannot access these abortion services, they end up doing things that they've read on the internet, which is never going to do anyone any good. So yeah, those are a few things.
Professor, I thought it would be a little helpful for the readers if you could put in a little perspective of how consent of like do how child's consent works with abortion. Like, can they consent or not, or is it parents doing so? Yeah.
Absolutely. That's actually another very pertinent aspect, because under the MTP Act, a person can consent to abortion. A woman, though that's the language used, so I will use it for this minute. A woman can consent to abortion. However, if they are under the age of 18, then they need their guardian to consent to abortion as well, which of course can again be really problematic, because I don't see a lot of pregnant young persons going to their parents and telling them that I'm pregnant. Unfortunately, we just don't have that kind of transparency, right? And there is still so much stigma that is attached to sex. So that within itself is also problematic, and the language in the MTP Act on this is also not very clear. However, we have had judgments over the course of the last few years, and actually even from many years ago, even from 1993, we have judgments which have said that essentially without the consent of the minor, the abortion should not be done. So, meaning whether to, at the end of the day, whether to choose to keep or abort the fetus is up to the minor. However, if they do want to abort the fetus, then they do need the added consent of their guardian. So, that is definitely also a hindrance.
Thank you, Professor. Um, I think, like you said, I think the larger issue when it comes to this discrepancy is also the age of consent. Because a lot of the abortions that, minors do go through is obviously also might be a result of a very gruesome sexual assault, but a lot of it is also because of consensual sexual activities that these adolescents enter into, and then they're being criminalized for um
Having
something just so sad. Yeah. And it just creates another added issue of like, and I think in general it's a big issue with law where there is not an actual lens of ground root realities of what things are. And because the law sometimes is blind to ground root realities, and like to have the parents consent in such things is also very tricky. And it again, I think it all comes back to age of consent also when it comes to consensual.
In
Yeah.
fact, the UNCRC in its general comments have also said that there should be unfettered access to reproductive health services for all young persons and adolescents. And they also say that the age of consent is one that shouldn't be too high or too low. And definitely in India, we are at the too high stage. So,
If I'm
although
not wrong, I think the comment also, like the UN had made a comment about the age of consent of India being too high, if I'm
too
not wrong.
low,
Or
yeah, being too high.
yeah.
Yes,
Yeah,
they
I
did.
think so. Yeah. So I just remembered that. Okay, to just follow up to the previous question, and I think it will be a great way to even conclude today's fruitful discussion, which is how do you think this can be remedied, which is the discrepancy, and what do you think our legal setup could do better for minor parents? I don't want to say just mothers, but in general, minor parents who become pregnant.
Um, I think following the mandate under ex versus principal secretary is a good first step. However, that is also fraught with difficulties, and I think with when it comes to young persons and adolescents, I think this is always the hardest debate to settle: protection versus participation. Right? I feel like that's really what a majority of the time it boils down to. And even in this case, I think one really needs to look at how is okay. I will try and break this down a little bit because I feel like I have so many thoughts on this. So I'll try and just give you the highlights of my thoughts, right? So I think a good first step is following the mandate in ex versus principal secretary. However, the only problem that I see coming up with that is it doesn't really fulfill why we actually have mandatory reporting. The whole idea behind having mandatory reporting is to ensure that the child can be, or the young person and adolescent, they can be taken out of the dangerous situation or the abusive situation that they may be in, and their safety can be ensured. Now let's see if it's a case of incest, right, which we know over 50% of CSA cases are they really going to want to report it if it's a family member who's the abuser? I don't think so. Right. So I think there needs to be some conversation there, even as to understanding how it is that the pregnant person became pregnant. Was it a result of assault? Was it a result of consensual activity? I feel like that is something that needs to be examined. Right. Because if it is because of something like incest or because of sexual assault, or any assault that happened without consent, then I think in that case, mandatory reporting maybe should kick in. Now, again, here, I think, again, even the other issue with mandatory reporting is no one is asking for the consent of the person involved, of the child involved, right, of the young person involved. So I feel like we need like more deep rooted change because all of these things are so interconnected. Because honestly, at the end of the day, mandatory reporting will only work if the young person is on board. If the young person is not on board, they don't want to testify, mandatory reporting is also not going to work. So I feel like it we need so much more. We need more of this inculcating of the right to participation of a young person into our legislations across the board. And with that, and I know maybe this is just very ideal, but with that, then accordingly applying ex versus principal secretary of health coupled with ensuring that the child's or the young person's right to heard is also at the forefront. So I feel like that is a good way to go about it. But I don't think that there is a perfect solution to this. However, I do definitely and strongly believe in the fact that a young person's access to reproductive health services should not be fettered by reporting, right? And I think we also need to think about, I think whatever system that we do think about, even if we are to include the right of participation and have all of those things in, perhaps judicial discretion maybe should not step in so early on in the process, because how many people really have the resources for judicial discretion? Like even the cases that we've spoken about today, so probably like 1/4 of the fraction of the not even 1/4, I would say 1/90th of the fraction of cases that are actually reaching court. How many people would have, how many young persons would have gotten impregnated and okay, RMP said no abortion, they probably wouldn't have known what to do after. Right, so I think along with all of this we also need better comprehensive sex education for young persons and young adults, and honestly for everyone across the board. So I think it's not like I can't give you one solution to this. There is so much that needs to be done and so much that needs to be done simultaneously. But I think definitely as a short term goal, the applicability of ex versus principal secretary of health should actually be thought through and implemented across the country.
I think that was a wonderful way to end today's discussion. Thank you so much, Professor Avantika, for joining us today. It was, I mean, I think the world of MTP and also looking at child rights and the POXO is something very strenuous, and I think in general does not have a lot of awareness, and that is truly the issue when it comes to reproductive rights, not just in India, globally. I think it's one of the least discussed and debated topics because it has so much intricacies, and it also comes down to just awkwardness. People people have when it comes to talking about people's autonomy over their body. So thank you so much, Professor. This was a wonderful discussion, and for our viewers, thank you for so much for joining us today. And please do go to our website and see our work and this edition. And we will also have another opinion piece which will be uploaded in the wire. So if you're interested, all the links will be down below. Thank you so much, Professor.
Thank you. All right.